So we're going to get started. Thank you for joining us for our Escrow 101 Masterclass. Good afternoon, everybody. If you're joining Facebook Live or if you're joining Instagram Live via Zoom or in person, we personally want to thank you for taking the time today to join us on this Masterclass. My name is Jackie Padilla, and I am honored to be hosting this exclusive Escrow Masterclass with our none other than Michael Walker here, who is an escrow officer, our escrow manager at 805 Escrow. And today we're going to be going over some of the, or we're going to equip you guys with some of the knowledge, strategies, and insider tips to navigate the escrow process with confidence and efficiency. As real estate professionals, whether you're a realtor or a lender or maybe even an investor, you know that a smooth escrow process can make or break a transaction. Yet, the escrow process is one of the most misunderstood and challenging parts of a deal. That's why we created this class. We want to give you the practical tools, insider knowledge, and problem-solving strategies to help you close deals more efficiently, avoid delays, and provide top-tier service to your clients. What you'll gain today is a clear understanding of escrow and how to streamline the process, proactive strategies to prevent common pitfalls and cause delays, insights on title red flags, loan funding delays and closing challenges, and best practices for communication between realtors, lenders, and the escrow team. Michael and I will also throw in some fun or scary stories or examples we have personally dealt with through the years to help you understand and deal with mistakes or problems you may run into in a transaction. We encourage you to ask questions and take notes. What you learn today will directly impact your ability to close deals faster, protect your clients, and strengthen your reputation in the industry. So let's dive into the escrow masterclass together. All right, Michael. So for anybody who might be a new realtor, what is escrow and what is the function of an escrow officer?
Got it. As you mentioned, my name is Michael Walker, escrow officer and manager, 805 Escrow. 25 years of being in this business, so I have a bit of experience in this. Escrow, what is escrow? We are a neutral third party. What that means is we take instructions, we don't give them. So your purchase agreement is our instruction. It gives us an outline of how we're going to handle your transaction. With that being said, once you send your accepted contract to us, the escrow fund begins.
All right. So we did print packages for everybody who is here in person. So that's what these will look like. The first part of our package and our first slide is going to be the escrow SOP. So this is a standard operating procedure that you as a listing agent should have in place to be able to open an escrow efficiently. And if for any reason you don't have this procedure in place, the escrow officer will go ahead and request these items that are going to be on this list attached. Do you want to go through the items?
Sure.
All right.
All right. So when opening an escrow, the best way to open it with an escrow holder is giving all the information you have accessible regarding your accepted contract. That includes the purchase agreement, any addendums there too. Any addendums that are attached to that contract or referred to in that contract are part of that contract. So submitting all complete documents is necessary for us to do our job properly and prepare paperwork in regards to that said contract. The listing agreement is quite important for compensation purposes, and the BRBC is also important for seller paid buyer broker compensation. The seller and buyer's information, whether that comes directly from the listing agent, seller information, cell phone number, emails, the buyer's agent may send their information separately, buyer's email, phone number, cell phone number, lender contact information. Transaction coordinator contacts. A lot of times you have a transaction coordinator that's assisting with the document process, so their contact information is important. On properties that have a HOA or solar, management company name, HOA name, the amount of the dues, solar company contact information, whether being paid off or assumed by the buyer. I believe that's about it for getting the contract opened with escrow.
All right. So for those of you that are here today or who may be attending live on Zoom or Facebook or Instagram, we do have a template, an email template that we can provide to you guys. And it is going to just go over exactly what that SOP is and what escrow would request normally in an opening. So to be a proactive agent and to kind of streamline the opening process, you can include all of these things that are included on the email sheet here in your opening email, and it will really help escrow. That way we don't have to spend time going back and requesting these items. So those items are going to include the fully executed RPA, the listing agreement, commissions as followed for listing and selling agent. We need that disclosed for both. The HOA name, if there is one, or the solar company information details, if any, and the seller contact information, including their email address. So that's what you should be including in your opening email to escrow. Bonus if you have the buyer's contact information, the lender's contact information, or the selling agent TC information, but escrow will always reach out and make sure that we get that information as long as you give us the buyer's agent's information. All right, so our next slide we're going to go into is going to be the California Residential Purchase Agreement and Joint Escrow Instructions. I'm sure everyone is familiar with this or has seen it once or twice. So Michael here is going to go over what escrow is kind of looking for and where we're pulling the information from, and just the importance of making sure that things are completed correctly on this form.
Okay, so broker representation agreement. For every transaction, the buyer is now, excuse me, required to be under an agreement with their broker. Their broker also has an agent that works for their brokerage unless they are a self-independent broker. That agreement indicates what the buyer is going to pay their agent as far as compensation is concerned. This agreement is between the buyer and the buyer's realtor. When you go under a real estate purchase agreement, you do have the opportunity to request that money to be paid for by the seller. Do we have that on here? Or so this is the buyer broker agreement indicating what the buyer is willing to pay for representation. Do we have another next page? Okay. The listing agreement. Do we have a listing agreement on there or no?
I don't think.
No? Okay, got it. So go to the purchase agreement, next page. Here we go. Back up. Okay. So where's the page with the page 2? Do we have go back one, page 2? RPA, page 2, yeah. Mm-hmm. Mm-hmm. It'd be with the RPA docs. Okay. 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 So any which way. So on the purchase agreement, page 2, G3 is the provision at the top of page 2. G3, it indicates what the seller is going to pay the buyer's broker. So that is a contractual negotiation. When the buyer's agent is writing the offer, they're going to indicate that they want the seller to pay the compensation to the buyer's agent. Usually that amount is the amount that is listed on the BRBC. So for example, if the buyer is not going to pay the compensation to their agent and the seller is, the buyer does not pay anything, right? So that is the agreement between the buyer, their agent, the seller, and the buyer's broker. Let me give you an example though. Let's just say, for example, the BRBC says 3%. And the contract is requesting 2.5%. You do have a 0.5% overage that is either due from the buyer or it can be removed with a modification to the BRBC. So that compensation can go down, it just cannot go up, right? So I'll give you a different example. The BRBC says 2%, the contract says 2.5%. The lesser sum prevails, right? So because the BRBC said 2%, the seller is only obligated to pay 2%, regardless of the agreement to pay 2.5%. So that kind of clears up the compensation in reference to the BRBC and the purchase agreement where the seller is willing to pay that compensation to the buyer's broker.
All right. Well, thank you. So yeah, make sure you have those things completed out correctly, because we don't want you to be paid less than you're expecting to be paid come the close of escrow because things were not filled out in the beginning of the escrow correctly.
Go to the
All
next
right.
page.
So our next slide is
This one.
going to be,
This page of the RPA. Go to the next page. There we go. All right. Very important page of the purchase agreement. Page 3. Page 3 references a lot of allocations of who's paying for what. Very specific. If the seller's paying for the natural hazard zone disclosure report, if the seller's paying for a wildfire report, smoke detectors, who's paying for escrow? For example, each to pay their own fees, title insurance, seller paying for the title policy. The buyer pays for their lender policy. That is a default now in the real estate purchase agreement. Who is paying for transfer tax? Who's paying for home warranty? So this section here, which is Q7 and Q8, is where you put 805 escrow. That's where you put the escrow holder.
every time.
So this is where we are figuring out as an escrow officer who's paying for what, so we can appropriately prepare estimated closing statements for the seller and the buyer. And I believe next page. Yeah, this one. Go back one. And this next page, page 4, is important also, because page 4, item 4A through C, indicates other documents that pertain to this contract that are incorporated therein. For example, disclosures, addendums, every type from tenant occupied property to a COP, which is, contingent on the buyer's sale or whatnot. So this section here has to be completed properly. And the documents that go with it must be provided to the escrow holder so we can do what we need to do. In regards to those addendums, without those addendums, we have no idea what those terms are on those addendums. So this part's very important to have complete and provide all of these other forms with the contract, including other, and there'll be a list of ones that may apply. You may have a broker affiliate disclosure. You may have other types of disclosures that are part of your brokerage specific. Those will all be listed there. Go ahead.
All right. So very important to fill out your contracts thoroughly. Make sure all of them are checked in the right boxes, and make sure that any appropriate line items that need to be filled out or typed out are filled out and typed out. All right. So
page 17 of the contract is very specific for the realtors and brokers involved and the escrow holder. So myself as an escrow officer, I don't sign off on this page unless I have the deposit. The only time I sign off on this page when there's no deposit is if the contract called for no deposit, which is quite rare. So this section down here will indicate the deposit amount that I've received, the counteroffers and addendums, which I would abbreviate if it's a BRBC or a COP or whatnot, I abbreviate here. And of course, I execute all my information, the company name, my signature. We are licensed under DFPI and our license number. So this will only be completed as me accepting to be the neutral third-party escrow holder of the deal upon receipt of compensation via the EMD or without the EMD if it's not part. And EMD is earnest money deposit. Okay. Good there.
all right. So once you get that deposit into escrow, we're going to go ahead and send a receipt to you saying that, hey, we got the EMD, the transaction's basically live at this point. And this is when escrow is going to start typing away and getting those opening packages out. So we want to go over what your clients are going to be receiving in their opening package. And we're going to start with the seller's opening package. So everyone here live should have a copy of the seller's opening package. And we're going to go through form by form and what they mean and what we need filled out and how to avoid certain errors on these forms. All right. So the first form is going to be the statement of information. Everybody hates filling this out because it has the most things to fill out through any of the forms. So everyone kind of hates filling this one out, especially, when you're doing the notary signing, the buyers are kind of freaking out. So this form is very important though. So Michael's going to tell us what this form means and why we need it.
All right. So for opening packages, we like to utilize DocuSign, very secure way of getting information, and the clients do not have to, hand write everything. They're typing it, whether it be on their phone or a computer. So the statement of information, this form specifically is asking for sellers' personal information. And I'm going to tell you why in a second. So it's going to ask for their first, middle, last name, birthplace, social security number, driver's license, residence history within the last 10 years, and occupation. The purpose of this is not really for escrow. It's actually for title insurance. So they're going to run this personal information to confirm that if there are any liens against the property, recorded liens that will show up on the prelim, if they're the client's liens. Someone could have the same exact name as me, live in the same county, and it not be me. In addition to that, unsecured liens, okay? So unsecured liens aren't recorded against the property, but they're still against yourself. So if there's a lien out there, a judgment that's not recorded against the property specifically, it may pop up and it may have to be settled through escrow. And that means paying demands, getting releases, and things of that nature. So the seller definitely has to complete this in a timely fashion in the beginning, and that's why we put it as the very first document in a seller open package. Everything that's to follow is for a purpose, and every document we're going to go through on this package is specific to the seller. So that is the statement of information.
All right, our next form is going to be the seller information sheet. And this one is very important. A lot of the time people are like, oh, I already gave you that information. So this form is very important for escrow because we do use it as a seller auth form when we are ordering something like a payoff. So Michael's going to explain what is going to be on this sheet and how to fill it out.
Okay, so this one specifically, I'm not sure if you guys can see it over there. It's actually referring to existing mortgages, right? But the seller information sheet has more info than this one. This one was created specific to the transaction that I was dealing with. This is one of my closed escrows. The reason why it doesn't have other information on there is because I may already have that information. So a standard seller information sheet is going to have existing mortgage, first, second, third. Do you have an HOA? What's that information? Is there water stock on the property? Do you have that information? And sometimes even, is there solar? And provide that information. So this one I edited because I knew there was either one or two mortgages only, and I already had the solar info and I already had the HOA information. So I'm not going to ask your clients to give me something I've already obtained from their agent, okay? The reason why I need them to sign this form is there's a paragraph right here at the bottom that gives the third-party escrow holder the authority to order payoff demands. Sometimes we have to email or fax them, so we need something in writing. This is our backup if we can't do it online or through a phone number with the specific information, loan number, last four digits of the social, and things like that. So this is the seller information sheet, okay? Next.
All right, so if you are a new agent and you hear the funny term FERPTA, that's definitely an important form, and Michael here is going to go over it and why it's important and what needs to be filled out on that form.
So as you know, you guys have CAR forms actually that talk about FERPTA, and that is a Foreign Investment in Real Property Act, okay? This is an IRS disclosure. The mere purpose of this form is for the seller to declare under penalty and perjury that they are not of foreign status. They have a tax identification number, whether it be tax ID for an LLC or corporation, or a social security number. When they fill this out, they give us their tax ID information and they sign it. I now know that I do not need to be involved with foreign withholding. Foreign withholding can get complex. It's either 10 or 15% withholding of the sales price, depending on a couple factors, sales price and the property use, is it owner occupied or not. So that's another class for another day. But this form is very, very important because I have to disclose and redact this form and send it to the brokers at Close of Escrow because they want to see it. You guys also are familiar with a form called the QS. This is the same thing as a QS. We are the qualified intermediary signing a QS CAR form for you guys because we can only sign that because we have this. They declared it to us, and we're declaring it to you. So we're not going to do any withholding. So your disclosures are good. There's no withholding. We have socials. They declared they are not of foreign status. Okay. So this is an IRS code. So this is more on a federal level. Okay.
All right. So the next form is the 1099 cert. So I'll just let Michael get right into that one.
Okay. 1099 certification. This is not the actual 1099 that they get at the close of escrow. Okay. That is prepared at the close of escrow. And why? Well, this has a price on it. The price may change, right? It's just an input form. They're giving us their names, their socials, their percentage of status of percentage of ownership. And is it their principal residence? Are they doing a 1031 exchange? And we're also asking again, are you a foreign person of non-foreign status? So this is like piggybacking the FRIPTA. It's letting us know if there's an exchange involved to defer taxes for, let's say, an investment rental property, or if it's principal residence, which we'll get to later, why that's so important, the principal residence, and the percentage of ownership. So let's say there's 4 sellers, right? They all have 25% interest. We need 4 of these, 25% each. We would 1099 25% of the gross sales price at close of escrow for the purpose of them doing their taxes next year. So not one person's on the hook for 100% of the price. 4 of them are at 1/4 each. Okay. So this is, again, just a data entry form that's providing information to us so we then can issue it later on, the 1099. Okay.
And then what if it's like in an LLC or if it's a trust, or how do they fill this out?
So in an LLC, there's a couple different ways. So an LLC that has more than 1 member, they're going to have a tax ID number. A non-recognized LLC is an LLC that has actually only 1 member, and it's usually described with a social only, right? So it's treated as an individual. Living trusts of original trustees are socials, okay? Tax IDs kick in when it's a successor trustee because the original trustor and trustee is deceased. So now you have to get a tax ID number. So the trust on a successor trustee is actually going to file taxes under a tax ID number that they obtained after the trustees and trustors passed and open a bank account in the name of the trust. So later on, again, we're going to 1099 the name of the trust, not the signer, not the successor, the name of the trust. So if it's like the Walker Family Trust, tax ID number 99- whatever. So that's going to go out, and then they're going to be able to file taxes in the name of the trust. If an escrow holder doesn't do this properly and they get the social from the successor trustee, that individual is now going to get 1099 for a property that wasn't theirs. It was the trust, right? So then that's going to have to be fixed. So it's very important that this gets done properly. Okay.
And also here on the bottom, make sure your sellers know that they need to put a mailing address that's not the property address, because they're not going to be there most likely after the close of escrow. So we see that a lot too, where the 1099 will go to the actual property address and they're not there anymore.
So normally if I were to see that, I just send an email before close, what's your forwarding address? Because sometimes they'll just say to follow, TBD. Okay, so clearly I'm not going to close without the address. I'm going to make sure I get that, even if it's family, friends, cousins, aunts, uncles, an address where they can physically get the 1099. Okay.
NHD, go straight into that one.
All right, so you guys are very familiar with the Natural Hazard Disclosure Report. Okay, that is issued by a third party based on state and local maps. It is not produced by escrow. We don't micromanage it, nor do we question the answers to the questions. This is just one page of the NHD that has the basics. Is it a high fire severity zone? Is it in a liquefaction zone? Is it in a wildfire fire zone, seismic hazard zone, earthquake zone? So that is required, actually. It's non-waivable. It's required for either the buyer or the seller. It's negotiable who can pay for it, right? But it needs to be issued during the transaction and the buyer signing off for it. So they are aware the location of the property when it comes to state and local maps, right? So most companies are pretty up to par when it comes to state and local maps. So they are updating their data daily, actually. So the seller will sign this, acknowledging that we have it and we're going to give it to the buyer, and the buyer is acknowledging receipt. There are signatures for agents. Now, I know a lot of brokerages want the agents to sign it. I don't require it. Principal parties in my transactions is seller and buyer, and I will never require the agent to sign it because you don't know the validity of it. So I'm not going to, require you to sign it and accept it. It's buyer to sign and accept, and seller to sign that they've received it also. Okay. All right. So we just talked about the FRIPTA, right? The affidavit of non-foreign status. This is called a cow FRIPTA, okay? Think of it in the same sense, but on a state level, okay? Franchise tax board, right? This form is actually saying what is required to be withheld if the property is not your principal residence, or if it's exempt from withholding, right? Or under a certain value. So in hindsight, this is talking about 3 1/3 withholding for the Franchise Tax Board. So when we get to that form a little later, I'll dive into a little bit more. But this form is basically saying that the buyer is the withholding agent. This is going to be odd, okay? The buyer is the withholding agent. Why is the buyer responsible to make sure the seller's Franchise Tax Board withholding is done? It's a strange way to think about it, but it's the way the laws are written. And when laws are written, they're not written for our purposes. They're written for other purposes. They think of it as this. If I'm a buyer and I'm giving you $1 million to buy your house, they want the buyer to withhold 3 1/3 of that $1 million because they're giving the $1 million. We as the middleman, we're a real estate escrow professional. It's called REAP. We're the middleman that's going to do that on behalf of the buyer. So when we get to that form a little later, I'll explain a couple more things. But this is just notifying the seller and the buyer of those requirements. And yes, I have received phone calls from buyers. I'm responsible to make sure their withholding's done. And then I have to talk them off a ledge and tell them, don't worry, I'm going to do it for you. So that's what we do. Okay, go ahead.
Amendments.
Yeah, this is just examples. We're giving a couple examples of some amendments that I do on my desk, right? And other companies may do. But things that are in the contract are what we're acting on, right? What if there's something we need to do that's not in the purchase agreement, right? An escrow act, especially when it comes to money. I paid $719.95 for somebody's HOA docs. We want that money back via reimbursement. So we do an amendment that authorizes us to take that money back from the seller's proceeds. And if it were to cancel and not reopen within 30 days, they're going to send me a check. Okay. So we'll just, if it reopens, we'll just put it onto the next file and we'll, get it at that point. So this is just an example of an amendment when it comes to terms that are created after the ratification of your contract and opening escrow. Okay, go ahead. Same thing with solar. Okay. A lot of times we're going to get a contract and there's solar on the property, and there's zero mention in the contract that there's solar. I strongly advise that you do have the buyer agree to assume solar in your contract. If it's not there, I now have some trivia to figure out. Are they assuming it? Is it being paid off? Is it a loan? Is it a lease? Who's paying for what? Are there transfer fees? Are there recording fees? All that good stuff. I identify all that information here, okay? Who's paying for what? I'm authorized to do the solar transfer. There might be releases that get recorded. Who's paying for it? And so on and so forth. So again, this is another contractual change that was added to your contract after ratification, right? Not superseding your contract. It's kind of added to the terms of the sale, okay?
And also on solar, I would say, if you're doing a listing appointment or even before you open escrow, you want to ask your seller these questions about the solar because they could be delaying the deal. So let's say you have a buyer come in all cash 7-day escrow. Most likely it's not going to happen if there's solar. If the solar company is going to take forever to kind of transfer that solar contract to the new buyer, or if you need to complete different forms for the solar, depending on what the seller wants to do with the solar. So make sure you have that conversation.
And furthermore, with what she's saying, very important, not all solar loans are transferable, okay? You're gonna run into solar loans that have to be paid off. That's non-transferable. Then you have the ones that are transferable, right? And they might take longer because it's an actual loan being transferred, not a lease. So a lease is completely different than solar. A lease is definitely different than a solar loan, right? So another thing you're going to run into specifically, and I'm just going to throw this out there, anything that says SunPower, they bankrupt, they were sold off to many companies. Some of those companies are taking up to 60 days to do a transfer, and I just experienced it, okay?
Yeah.
So very, very, very important to understand exactly in the beginning, read their solar contract, email it to me if you need to, and I can tell you what I see, if it's transferable or not, or it has to be paid off, or if it's a loan or it's a lease. That information is super pertinent when it comes to putting contractual terms together and the timeline for your escrow, okay? So very important. Go ahead. Subtax amendment. Okay. So this amendment, after many years of doing this, I created this amendment based on just my own personal experience of people not understanding how supplemental taxes work. By giving all this information at day one when you open the escrow, no one can say they did not know or weren't told what the triggering events are for supplemental taxes.
Yeah.
Give you a prime example. I have to file an affidavit of death for someone who died and the successor trustees handling the transaction, right? That is a triggering event. They're going to reassess the taxes from the first day of the preceding month of the date of death. If it was 3 years ago and they never filed an affidavit of death for that person who died, they waited till it went into escrow to sell the property 3 years later, they're going to be due an unsecured supplemental tax bill way back from 3 years moving forward from a reassessment from that time of recording. That means they need to save money in that trust bank account where I talked about with the tax ID to pay that money, because it's going to be money coming up. It's not going to be attached against the property. It's going to go on the unsecured tax roll. So what are the triggering events? Affidavit of death, grant deed, which is the purpose of the sale, right? That's the main one. The sale is going to be the reassessment. Building permits. If the seller was doing building permits before they sold the property, those might pop up after, right? After we already close. Buyer might get this bill and say, this is not my bill. Then they have to let the tax assessor know that there was a transfer of ownership, and then they put it on the unsecured tax roll. So this very detailed amendment goes with every single one of my transactions. So everyone knows, again, the triggering events for tax reassessment, and it prevents questions later on. If they read it, I still get the questions, but it's helpful. It's helpful. It's helpful information. Okay.
Yeah. And again, I want you guys to just realize that not every escrow company is going to do these types of amendments. 805 escrow is white glove service escrow.
Mhm.
So we don't want, your clients to call you freaking out about something that they didn't know about. We don't want your clients complaining, hey, I didn't know that this was going to happen, or that this is why Michael prepares these particular amendments. It's not so your clients can sign more paperwork. It's really to explain and avoid hard conversations that you might have to have with your client later on.
And I've worked for other escrow companies. That's 99% of the other escrow companies do not go the extra mile in regards to the amendments, the legal verbatim that goes with it, the mathematics, the timelines, controlling the timelines of your contract. Everything has a purpose. Everything that you're going to see, or everything I talk about, has a purpose of the same goal that everybody has. But a lot of this is done behind the scenes that you're not seeing. So amendments like this, and even amendments in how you handle a SIP or RLAS, very, very detailed, because those forms are very minimal information given there. So this is just one tiny little smidget of an extra document that's going to save a headache later on behalf of your client and will be helpful. Okay. Okay.
Oh, the fun stuff.
Want me to do this one? Okay.
Yeah, go for it.
The fun. Okay. So is everybody familiar with the recent car contract changes when it comes to compensation, aka commission, right? The previous contract change allowed everyone to see your commission, right? Now it's a little bit different, okay? So the new contract will indicate that we can disclose the listing broker commission to the seller, and the listing broker signs off on it, right? Because that's per your RLA. So this refers to the listing agreement. I'm doing one agreement pursuant to the listing agreement. I'm going to do another agreement pursuant to page 2, G3 of the purchase agreement. And page 2, G3 of the purchase agreement is that seller paid compensation. In that paragraph right below, it actually refers to that the buyer is aware that they have an agreement with their broker for no less than the sum above, which is the amount that their agent is asking the seller to pay, right? So it's important for a couple signatures on here. The seller to sign because they're paying for it, right? The buyer's broker because they're actually the due party. If you're not a broker, you're a salesperson, they're the due party of the compensation. They can give us a CDA to cut checks. And why would the buyer sign it if they're not paying it, right? Well, I would think probably because the buyer needs to see they're not paying it because they agreed on the BRBC to pay it. Then they know that the offer went in and they asked for the seller to pay it. Then the seller agreed to it. Now we're letting the buyer know this is how much you're not paying because the seller's paying it for you, because they are paying it for the buyer, essentially, when it comes to a contract. So there'll be 2 compensation instructions, right? The only time there'll be a third is if there's a separate BRBC overage or agreement, right? So let's just say there's a 1% overage and the buyer's broker is actually going to charge the buyer that. And I've had transactions like this. There'll be a third one. And the third one's going to be between the buyer and the buyer's brokerage for that 1% because the seller paid 2%. There was a 3% BRBC. Now the buyer is going to sign for that 1% and they will be charged. So that becomes 2 compensation instructions or 3. Okay. We don't have the third one here, but the third one would apply only if you're charging your client and you're on the buy side. Okay. Yep. That's control.
Oh, okay. So this form, this is going to be our escrow instructions. I'm sure everyone has seen escrow instructions before, or at least a sample of escrow instructions if you are a new realtor. So the escrow instructions are really important to go through. We do pull a lot of the information from the contract, but Michael's going to go through exactly where all of that fits in and plays into our instructions.
So right at the top, it shows our license number. We're an independent escrow company. It says escrow holder supplement to California residential purchase and joint escrow instructions. So what does that mean? That means you have a contract and this is a supplement to it. Okay. Page 2, which I'll get to in a section, it actually has a provision that states that any conflict between your contract and my escrow instructions, your contract prevails. Okay. So your contract, my escrow instructions can't change your contract. Just know that your contract is your contract. So in this section here, the first paragraph, I'm actually stating I received what kind of contract. It could be an AIR commercial. It could be a vacant land. I'm going to indicate it. And I'm going to indicate it up here, what kind of contract. And I'm going to say what I received, when it's dated, and then I got an AAA. This was before the contract change recently, this example. So there was an SPBB, a BRBC, SBSA, MCA. So I'm referring to everything I got. Here I'm going to have the mathematics, which sometimes between the time you guys open the deal and by the time I type this, which is like 48 hours later, the loan amount changed. So it might have a different loan amount, right? So that's going to be in there. Then we refer to a legal description, which is attached at the end, the buyer's name, the property address, free from encumbrances. That just means all taxes are going to be paid current except for the next physical tax bill that's not out yet. Then we got down here, finances. Well, we don't know the full lender details yet, so we just know there's a first trust deed in that amount, and we'll figure out the details later. And then going on to the next page. So escrow instructions, really the first 2-3 pages is all you really have impact on anything. So page 2, we talk about our disclosures, affiliated business, conflicts with the purchase agreement, like I just mentioned, actually says that the contract prevails. Then we talk about the natural hazard, who's paying for it based on the contract, home warranty plans, who's paying for it per the contract, HOA docs, who's paying for it per the contract, and the civil codes that go along with that, right? The new contract actually talks about seller only being responsible for items required by civil code. The old contract actually had a spot to say things that are not required by civil code. That's been wiped away. So we only request what's done by civil code. Deposit of funds, and then just moving forward, prorations. What are we prorating? We're going to prorate taxes, interest on encumbrances, which is payoffs, and HOA dues. Now, if I had a SIP, some kind of a SIP or RLAS, I might have rent prorations, or let's say it's a 4-unit building and there's people renting, right? Then I'm going to have rent prorations, and then I'm going to get rent statements and all that. So, and then we just have our standard disclaimer and then signatures. After this page, do we have anything after this? After this page, general provisions. Okay, whether it's you, the next person, this contract, that contract, commercial contract, vacant land, residential, doesn't matter. General provisions are all our general provisions that give information of what we're doing as a neutral third party, right? What we're doing in regards to our duties as escrow holders, clauses regarding indemnification, how deposit of funds are handled, personal property taxes, everything. So most people, it even talks about RESPA guidelines, Real Estate Servicing Procedure Act, property insurance, everything. So most people aren't going to read all of this, right? But sometimes you might have a lawyer that does. And then you'll get the phone call and they will cross out everything, and then I will send it back to them and say, you have to sign it. It's not, we can't change it. We don't change our general provisions. They're there for a reason. It's information and protection for everybody. But it's information necessarily, information for the clients, okay? You can move on to the next slide after the next one. Privacy notice, affiliated business disclosure, and state. So this is just like a privacy notice on a federal level, privacy notice on a state level, how we keep the information private, your clients' information private, and affiliated business disclosure, who we're affiliated with. We're affiliated with a title company. These are estimated fees. These are the estimated cost of the title premiums based on sales price. So again, just information, disclosing, just like anybody, any brokerage would disclose who they're affiliated with. Same thing applies for us. And then we go to the next. And the legal description. So the legal description. What you guys may not know is the property under recorded records is not identified by the property address. It is not. When you record a grant deed, you're recording it, it's saying the property address, it's saying the APN parcel number, but it has a legal description. All records on the county level are actually identified with the legal description. The importance of a legal description is huge. It talks about the lot, the tract, the parcels involved. Even this one declares about easements because it's the common interest development like a condo. So this is very important. If the legal description is wrong, you may not own your house as far as the county records are concerned. So very important that you use a title company that is good and uses the proper legal description and puts that information out, because I'm getting this from the prelim report. Again, third party, I'm an escrow holder. I'm not the title company. So I'm going to rely on someone else to give me this legal description and identify it in the escrow instructions to go along with the escrow. And then this same information will be attached to the grant deed for the conveyance of sale. The property tax assessor actually uses the APN parcel number to identify the tax roll. So they use the APN, county records use the legal description, we use Google Maps and we use the address. So that's the difference.
Also, on a side note, I know recently there's been a lot of fires. So if a deal has closed and that home has burnt down, you can always request from escrow a copy of this because you might need it on your rebuilding plans or anything like that with the city.
Okay, seller estimate. Seller estimate, basically, it's all the mathematics in a nutshell. Debits, credit, basic mathematics, right? Purchase price, credits, debits, of course, it equates what the proceeds are going to be. It identifies everything, though, in separate sections, so it's very easy to read. Familiarize yourselves with it. You might have your client asking questions about what's what or what does this mean. You can help them or you can have them call escrow, right? Either or is perfectly fine. But prorations of taxes, prorations of HOA dues, commissions, HOA, miscellaneous would be anything from notary to home warranty to TC admin fees to reimbursements to SunPower for for solar transfer fees, title fees, taxes, and then escrow fees. So it's all broken down pretty simply for you to see and your client to see and understand. And I think.
And also on estimates, I recently had a refinance that we had, and during COVID, a lot of people got like those payment deferral plans, you know, so that way they didn't have to make their payments. So that is actually starting to come up, and you'll see it on your closing estimated statement. And I've gotten a lot of questions on it. What is this? What is this? You know, $26,000, $46,000. It is part of the payoff, and it is a separate line item on some of the payoffs. So that's how we have to show it on our estimate. So just keep aware of that. If you have clients that are refinancing or maybe selling, they might see that on their closing estimated statement.
Yep. So called deferred principal. So it'll be a separate line item, separate non-interest bearing principal. That's going to be there with the principal, then interest, then other costs, all broken down. Okay. So notary items. Okay, these are the notary items. When I have a transaction, I do a lot of it in DocuSign. So things that require a wet signature or notary are done later. I like to wait until contingencies are removed, because why send a mobile notary to your client to have them sign documents ahead of time if it's just going to cancel and then they incur that charge? In certain situations, we may cover that charge, or they come into the office, and I might notarize them myself. It's different for every transaction, right? And business that we have. But this is the grant deed, and it's just an example of this section is where it's mailed to after closing, which is the buyer. Here's the transfer tax for the county, because the city of Camarillo doesn't have transfer tax. If it was Los Angeles, there'd be a secondary transfer tax there. The person deeding out is how it's on title. The prelim, it shows who owns the property. That's the person deeding out. And they're granting to the buyer, right? And then the legal description's attached, and then the property address. So page 1 is identifying the APN parcel number. Remember I said the tax assessor used the parcel number? There's a form called the preliminary change of ownership form that gets recorded with this. When this gets recorded, a separate form called the change of ownership form is sent off to the tax assessor. So imagine this being recorded, now they own the property. Well, based on that sub-tax amendment I told you guys about, the property needs to be reassessed on the purchase price. So a separate form signed by the buyer, the receiver of the property, goes off to the tax assessor and says, reassess me, it was $1 million. Now they're gonna reassess it based on the tax rate because I gave a change of ownership form. It's very important because they can't reassess the taxes if that's not filed with the grant deed. But that's something the buyer signs, so it's not part of the seller package. Next page. The next page is actually, this was in a trust. So there was the trust name, the name of the client, trustee, name of the client, trustee, and then they're notarized as individuals, not like as trustee or any type of capacity of the signer. It's just individuals being notarized. And I put my stamp there, I fill it out, and then the next page is the legal description. We're back to the legal description. This is what identifies the property of public records. So we have the PCOR, change of ownership form, preliminary change of ownership form, going off while this gets recorded. And now we have reassessment of taxes kicking off from the acquisition date. And then we have this recorded at close that I'm going to get from the title company and send it to the buyer with their closing statement saying, here's a copy, original to follow from the title company. Now they have proof of ownership. Put their utilities on, contact HOA, that kind of stuff.
And just a little tip, as a notary, I would always suggest if your escrow company, if they're producing the grant deed, to have them make it 2 pages so that the signature page is on the second page. I've gone to go do a signing and they accidentally put like, Sally Smith, a married man. It's not a man, it's a woman. So escrow can correct that page because Sally Smith did prove she is Sally Smith. So, just make sure when you're working with other escrow companies, you're getting a 2-page grant deed. Just ask for 2-page grant.
Or just open with 805, I'll take care of it. 2 pages. Trust cert. Okay, so living trustees. If your clients are living trustees, don't think of it as a different type of deal. It's not a trust sale. It is a person selling that's owning in their living trust. Absolutely nothing changes, except you might have a RCSD section in the contract or a separate one showing their capacity as trustees and trustors of their own trust, right? So there's nothing different. Escrow does not need a complete copy of their private trust agreement. We don't. Title companies just want a trust certificate signed and notarized between the trustees, who are the trustees and trustors of their own trust, saying that they have all these powers, signing and getting notarized for their revocable trust within the last 6 months. What's a revocable trust? A trust that can be changed or amended because you're the living trustee. If everyone's dead and the successor trustees are kicking in, it cannot be changed. That becomes irrevocable. That's a different ballgame. I'm going to need your whole trust agreement. I'm going to identify the successors. I don't care about who's the beneficiaries. Who's the successors that are authorized to sign? The title company will review it. They will approve it. I will give them that, and then I'll have the successors sign and notarize a trust certificate. So the 2 things would be required. When a successor is kicking in, you can call that a trust sale because the trust is selling the property with a successor on behalf of the trust. Individuals that are selling the property in their trust is just like everybody else. They just happen to hold their title in a protected trust. Okay? Page 2, I believe, is just the notary section. Yep, we can go past that. Okay.
Okay, so instructions for proceeds. So not all escrow companies will have you notarize this form, but it is such a vital form and it is so important for us to confirm and for your sellers to really confirm where they want these proceeds and make sure that it is them and their account. I think we have a portal now, right, also?
Yeah, so basically with this one, we've got a notary being asked, okay? This was a deal I closed last month. We now have a new portal called Certified. It's insured, it's protected. They verified the identity of the receiver, meaning we put all this information in, they're gonna get a code, a text code, they're gonna get an email, they're gonna have to verify themselves, they're gonna be able to fill out their wire information. But this system is pretty intense because they're gonna actually, they have access to data where they can ask you, kind of like when you get the security questions, we're like, where's the last home you lived on? Was it on this street, that street? It'll be kind of like that, right? So we don't need it notarized if we go through that insured portal, which is protecting everybody, your clients, everybody, the company. But in some cases, we send this out if it's like an LLC or entity, because sometimes it's hard to identify one singular person that is part of an entity that has 15 members, right? So there's certain scenarios where we're going to have to revert to this, but we do have another system. And another thing that's really important is let your sellers know that they're not going to get money in their cousin's account or their business account if they own the property, not in that account, right? So a trust of their living trustees, sure, you want to put it in your individual accounts, no problem. You're both alive, you're both individuals, you're both signing as trustees, no problem. Successors are going to have to give me the bank info for the trust that they set up with that tax ID number, and it's not going to say Mike Walker, successor trustee. It's going to say the Walker Family Trust, because the person has nothing to do with it. Their signer does not mean they are the beneficiary. They're just acting on behalf. So the trust is going to be the bank account that has to be on there. If it's Walker and Associates LLC, it must be that. I'm not going to send it to your other corporation. So they just need to know we can't divert money. We can't pay off your cousin because you placed some bets, right? Through escrow. We're just not going to do that. So proceeds go to the holder on title, period. There's no gray area with that. It's black and white, okay? And notarization is very important if we don't have it through the certified system, okay?
All right, I'll let you take this one because
All right.
there's a lot.
This is the fun form. Franchise Tax Board Form 593. I'm sure you guys might have clients call you and say, you got this form. If an escrow company just mailed it out to them and didn't have any verbal communication, they might get this form and not know what to do. At the very top of this form, it says right there, REEP, real estate escrow person. That's what it means, REEP. So yes, REEP. So the top section has our tax ID number, because why? We are going to be the middleman doing what I told you earlier about. The buyer is responsible for the seller withholding if they do not qualify for an exemption, right? So the top part is us, because we are the remitter of this information. We are taking responsibility and remitting, not the validity of it, but that we asked for it and they signed it under penalty and perjury. The second section is going to be the client's names and socials and phone number and percentage interest, right? And their address, whether it be their current address or forwarding address. Part 3, very important. The only way you're going to have exemption and not have to have escrow get involved and withhold money, which I'll try to get to through these scenarios quickly, is it your principal residence and have you lived there 2 out of the last 5 years under IRS section code 121? That means 2 out of the last 5 years. But number 2 says, well, it may be your principal residence, but is it without regards to the 2 out of 5 year period? What if you're in the military and you had to sell your house a year in, right? So you would select number 2. Doesn't mean you're not exempt. It means I'm not going to withhold, and you're just not saying you were there for 2 out of the last 5 years. So they would select number 2. Number 3, seller has a loss or zero gain. If you select number 3, we'd have to go to page 2, which we'll get to in a second, and fill out the mathematics. What'd you buy it for? What's your sale price? What's your cost? Or what's your basis, right? For example, someone dies, what was the appraised value at the time of death? That's called a step up in basis, right? If the end result is a negative number, it's a loss, I am not going to micromanage the math and say, well, that's not true. How would I know? They're saying it's a loss. I'm not withholding any money. I'm going to send this to the state of California. They're going to see it. Then they're going to file their taxes next year and have to prove it, right? Other ones are going to, just real briefly, are going to be like, is it a LLC that's more than one member and they have a permanent place of business in California? Is it a corporation in California? They're exempt. They're going to file their taxes separately. So like an individual, an LLC that's run by one person that has a social, absolutely not exempt, okay? So These are just different things. And this section down here is for like investment properties where someone's going to utilize a 1031 tax deferred exchange. Their hands don't touch the money. They're exempt. I know this because I'm getting the exchange docs. They're signing them. I'm sending the money to the exchange company. So clearly that answer is right, and I know it's right. If they try to say I'm doing a 1031, but then I have to wire the money to their account, clearly I'm not going to do that. I'm going to say you have to redo this form because you're not doing a 1031. I would know because I'm sending the money to them. Page 2. We'll skip the top portion because that's called an installment sale, and that's a little bit complex for another day. But the bottom portion is where they put the math. Remember I said about the loss, to declare a loss? That's where they put the math. Another thing they can do is declare what's called a realized gain. So if it's not a negative number, it's a positive number. They gained $50,000 on the sale, at least based on their estimated math. The finite numbers are going to come with their CPA next year, right, when they do the taxes. I'm going to withhold 12.3% and send it to the state based on their gain, so 12.3% of a smaller sum. If there's no exemptions at all, I'm withholding 3.33% of the sales price. It's not a finite number. It's the mandatory maximum minimum. It's both maximum and minimum when you're not doing any mathematics. You're going to just withhold 3 1/3%, send it and say, good luck to your taxes next year. Figure out if you owe them more or you paid them too much and they owe you a refund based on your financial gain, right? So a lot of people don't want to do this math up front. Just withhold 3 1/3. We'll send it, and then you can figure it out later. You'll have a credit on your social from us to the franchise tax board, the state, not the IRS, for taxes next year. We do not get involved with withholding for the IRS at all unless you are a foreign seller. You do not have a tax ID number, and you have no social. You're not filing taxes. You're not a U.S. citizen. You're not a permanent resident. You don't have a green card. Those are different scenarios in which we would withhold for the IRS, and there's several IRS forms involved. I do specialize in those types of deals. I've done several. So I do know all the IRS forms that are involved with that and the process. And believe it or not, who's the withholding agent on that? The buyer. The buyer has to sign those IRS forms. They don't know what they're signing. They have to sign the form saying, I'm the withholding agent, and I'm telling escrow to hold all this money, your money. So you need someone who really knows what they're doing to help prepare these forms and have everyone sign for them to feel that confident that their signatures are on an IRS form talking about withholding someone else's money. I mean, that's a big, big deal. So you have to understand these things. And for another day, another class, there are other exemptions for non-withholding. It's called the substantial presence test in the United States of America, but that's another class. So, okay.
All right, so everyone should have the buyer's packet. It's a separate little packet.
This one's going to be much quicker and easier. The buyer.
Yes.
Sellers always do more.
Yes.
When it comes to escrow. Yeah.
Oh yeah, and on the previous form too, if you call an escrow company and you say like, hey, can you explain this form to my seller, or my seller doesn't understand, escrow is technically not allowed to tell the seller what to put in that form. That has to come from a CPA or a professional, but a professional like Michael will explain the form and the options that the form offers. So there's a difference.
Correct. And then what she's getting at is 99% of other escrow companies, and this is 100% true, just call some and ask them, will you help me understand the 593? No, we're not legally allowed to talk about it like a robot. Yes. That's what they say. We can't legally help you. They won't sit there for 10, 15 minutes and say, okay, well, based on your situation, A, B, C, and D could apply. So let's talk about it. And EFG absolutely does not apply based on your ownership and your situation. I'm literally going to tell them, you could pick 1, 2, or you could pick 3, and you could do realized gain or loss, send it to your CPA. We could do principal residence. I'm going to help them make their own decision, but making them understand and feel comfortable and bringing it down to layman terms is important, because that's going to be like the success of your transaction, the communication with your escrow holder. They're going to feel confident every time they call. You pick up the phone, you answer the questions. Not that, sorry, I can't help you. Like, we're not allowed. That's what everyone's going to say, because every escrow company does that. So she's correct. They'll get that type of assistance when they work with us. Sure.
What if it's a former U.S. citizen that's now a foreign national here in the U.S.?
Foreign national meaning they relinquish their citizenship. They're going to be,
And they're now here in the US selling the property.
and they're now here in the US selling the property. They would have to go under the substantial presence test. So basically, the minute they relinquish their citizenship, I actually had this recently where someone actually went back to Australia, relinquished their citizenship. We had to do withholding. So do they have the substantial presence test, which I can get that to you, the actual test to you, if you want to share it with people later. There's a certain amount of days in the calendar year that you have to be in the US, and then the preceding 2 years, equating to a full amount of days of being here in the US. You can't just be abroad and fly in and sell your property and think you're not going to have withholding. Specifically, if you gave up your citizenship. If you have dual citizenship, that's different, right? You might be in and out of the country. But the minute you gave up that citizenship, it gets a little trivia. I'd have to see the exact circumstances before I can answer it like 100%. But based on what you're saying, it just sounds like it is a foreign person, essentially. Meaning, would they be able to sign the FRIPTA? If they can't sign the FRIPTA, I'm withholding. And I'm going to withhold 10% if it's owner-occupied purchaser under a certain sales price, or 15% if it's over a certain sales price, regardless of the use of the property. It's ironic that the IRS cares about the buyer's purpose for the house. They're saying if you sell it under a certain price, I don't have the price off the top of my head, but if you sell it under a certain price, and the buyer's going to occupy it, oh, we'll withhold 10%. But if it's an investor buying it, we'll take 15. It's the strangest thing. I don't know about
Is
it.
that for like, well,
It's for foreign withholding.
Yeah.
Yeah. It's the use of the property impacts the withholding under a certain sales price. Okay. Otherwise, after a certain sales price, 15 across the board. So, okay.
all right. So first page of our buyer package is, again, our favorite form to fill out, the statement of information. So
Okay.
why does a buyer need to fill out? a
Yeah,
statement?
so less reasons for the buyer. The buyer's filling it out because not all title companies search the buyer, but a lot of them do. Well, why? Well, that buyer didn't pay their child support for a long time. Now we're able to tell them, when you own this property, day one, that child support judgment is going to attach to the property. The title companies that actually search the buyer's information are going to notify me a supplement saying this is going to be on the final policy. I'm going to notify the buyer and have them sign off. I approve this being on the final policy. Because remember how title companies give free and clear policies? They're giving a free and clear policy from the seller, but now you're going to have an item attached that's an exception to the policy, which is going to be the child support. That's going to attach, and that's going to come up when they go to sell. Doesn't mean they owe anything. Are you paid to date? Fine. When you go to sell or refi, you show the installments are matured up to that point, and you're fine. You can get a release. So that is the whole purpose. Why do you want my social? I'm buying all cash. I'm not even getting a loan. That's why we want to let them know. The title company wants to let them know that there's a lien that's going to follow them. Okay.
You want to just go right into the next one?
Yep. This is just a buyer info sheet. And then we'll ignore the one on the right. That's the CalFRIPTA. Again, the buyer and the seller both sign the same disclosure. The state withholding requirements. The buyer is now being told you're the withholding agent, even though escrow, the middleman, is going to do it for them. Buyer information sheet. It's for fire insurance, homeowner insurance. Super, super important. The minute we get an NHD report and we see it's in high fire, I proactively let the buyers know. And I say, please contact insurance carrier. It's in a high fire area because they might need a wrap policy. They might need a fire insurance policy with California Fair Plan and a separate, it's called a DIC policy. It's a difference in condition. It's a second policy that covers everything else. Both of them equate one policy. It's more expensive. But we want this information as soon as possible because it can delay the ability to close. Without having your evidence of insurance effective the day of funding, whether it be the day before close or the day of, we can't. And most lenders won't even issue loan documents without insurance. So from day one, the buyer should already be talking to insurance agents. The minute they get accepted, even before acceptance, if they know they're getting acceptance, already start the conversation. So that would cover these two because we talked about the CalFRIPTA.
Next one's NHD again.
NHD, we already talked about. The buyer is going to be acknowledging the zoning of the property because why? They need to give us that fire insurance information. And now they know it's not in a fire zone, this one, but it's an area of potential flooding. So do they want to I don't know, a flood policy, right? So this information is going to help them make decisions on what they want to do for insurance for the house, right? Seismic zone, if it's on a seismic area or liquefaction like water underneath, but seismic area, they might want earthquake insurance. It's expensive, but if you're literally on the fault line, you might want earthquake insurance, right? And we already talked about the other one. This is the instructions to pay compensation. So we can move out of that. We talked about the supplemental tax amendment. Now, you're noticing duplicate forms, right? Why is the buyer signing duplicate forms? Because we're notifying them the same information we're notifying the seller. If it's not private information, right, that only involves one party, right, like the seller or the buyer, we don't need to separately, prepare documents, right? So sometimes I have to draw amendments that pertain only to the seller and only the listing broker or only the buyer, and only the buyer's broker. If there's a lender, though, they're going to know everything. They get it all, right? They get it all. But these type of documents that are like amendments that I add in addition to every single transaction that are standard, or if it's applicable, like the solar one, both parties are going to sign because they're mutually agreeing that they acknowledge this information. And then you can move past this. This was the old commission. When everyone was on the same commission form, disclosing everything to everybody, this transaction was like before the contract change. Same thing, the escrow instructions that we already went through, buyer signing the same exact escrow instructions. There is no different version of anything to anybody, right? Anything that's a mutual agreement between a buyer and seller is going to be transparent by way of escrow pursuant to your contract. And like I said, some things that don't apply to a seller or buyer will be done separately between the parties that it is involving. And all of this is escrow instructions. And the buyer estimate, the same thing, right? Basic debit credits. Credits, debits, prorations, HOA, miscellaneous, title, escrow. One thing I will say that people don't understand is tax prorations, okay? The fiscal year, not physical, fiscal year of a tax season is June to June, right? So when you pay your taxes in November, always think of this, the end of the year, November, between November 1st and December 10th, that is first half taxes. So just think of it backwards. First half, end of the year. Second half, beginning of the following year. It's odd that it's due November 1st, between November 1st and December, but it covers backwards in time from July 1st to December 31st. So if you're paying at the end of the year, it's covering the last 6 months of the year. So it's backwards, then forward. Then the next year, you're like, man, I already have to pay by February 1st. I just paid in December. Well, it's due April 10th. So if it's due April 10th, it covers backwards in time from January to June 30th. And now we just ended back where we just started. Now we're back to where now we're doing first half and second half. So right now, if someone were to close today, I'm debiting from, what's today, the 29th to 7/1. I'm sellers paying the taxes that are due right now, even though they're not due till April 10th. The bill's out. Why? Because the bill came out last year. It's a 24-25 tax bill. So why not just pay it and make everyone's life easier? Pay it, debit the buyer from the close of escrow to July 1st and credit the seller. Get it out of the way. Now they're clear all the way to July. Now they're going to get the regular bill coming up, and then they're going to get, what did my tax amendment say? Supplemental tax bill. Depending on when you close in the year will determine, are you getting one bill or is it broken up into two? And they're going to give you plenty of time. The due date's not like the next day. It's plenty of time, but it is the step up from the sale price of the purchase and the acquisition price when they bought it, or when it was last reassessed, right? They added building permits. They got reassessed. They got permits. So it may be pretty close to the value that they're buying at, or they haven't had a tax reassessment since 1972 and the semi-annual taxes are $350. It's going to be a big supplemental bill, right? Big difference in value. So you'll notice that. Anytime you see taxes at a very small amount, you could always warn your buyer. Well, they had that from the 60s, so just prepare, put some money aside, or they have an impound account with their lender, right? And they're going to prepare for it based on the tax rate, based on the sales price. They're going to calculate what they need to collect for future bills. Okay?
All right. And I think, yeah, that's the end. So, yeah, does anybody have any questions or anything like that for Michael before we wrap up?
So
You mentioned for firm stuff. So how many percent you guys will hold?
So for which one? For the state of California? Okay, so the state of California, without any exemptions, without doing any math or realized gain, it's going to be 3.33% of the sales price. And then they file taxes next year. Now, this is true for a person that's not a US citizen, and it's also true for a person that is a US citizen if it's an investment property and they're not doing a 1031 exchange, meaning they're selling like a rental property. Think of the state and the government as give me money now, try to get it back later, right? So, you know, if you run a business, you do quarterly tax payments based on what you made the last year. Think of it that way. Hey, escrow, give me some of that money. And then when they file taxes next year, I'm going to get more. But at least you got a deposit, right? Because I might have to chase them for that money for a couple of years, right? So it's us giving them money up front in lieu of you doing taxes next year. And then you figure out if you owe more or less. Foreign withholding is 15%. And I don't know offhand the cap amount. I think it's under 300 or I got to look at the numbers, but it's either 10% or 15% of the sales price, which is an astronomical amount of money. If you think about multi-million-dollar property, hundreds of thousands of dollars I've withheld from sales.
Goes to states.
To the IRS, the federal government, the IRS. So the 3 1/3 goes to the state of California, that's state taxes. And then the IRS just put 15% or 10% question mark. 10% is under different circumstances, okay?
You guys pay
We send it, they can try to get some of that money back, exactly, yeah. And we are involved with ascertaining the proper paperwork to file that. Because I actually need, these papers change every year. I have to know what forms the buyer and seller need to sign. They're going to have socials on there, their information. Again, the buyer is the withholding agent. I'm going to help them help themselves by helping them with the forms that they're going to sign and agree to, so I can send that check to the IRS at close of escrow. Okay.
All right, any more questions? I have a question. So I get requests for net sheets all the time. So if I wanted to expedite that request over to you, what items do you need for a net sheet so that way we can get it quickly over to the agent?
Net sheets, that's the seller side, of course. Buyer's estimate, really is no buyer estimate. Just want escrow fees, title fees based on a buyer, sale, purchase price, and a loan amount. That's all you're really going to get. But mainly for sellers, a net sheet would be the property address, the purchase price, the full commission, if you want it all clumped together or separated between listing and buying side. For transparency, you could ask to separate it. Is there an HOA? How much are the HOA dues? All right, are they monthly, quarterly, semi-annual, or annual, right? Those are only really options for an HOA. Is there more than one HOA? Because then there'd be calculations for two. I'm estimating, I'm doing HOA prorations, and I'm also estimating what the costs are to get the HOA documents for 1 or 2 or 3 HOAs. Is there solar? Is it going to be paid off? Is it going to be transferred? Because there's some kind of cost involved with that. What's the mortgage payoff? Is there a first? Is there a second equity line? Is there, something else? Is there a third, right? Like sometimes people have a third loan. So as much information as you can get that is going to affect the estimate by way of a charge, right? Start off with the purchase price. Think about everything you can give to make the most accurate estimate by way of a cost to your client, right? The net proceeds is exactly what it sounds like. It's not gross proceeds, it's net. It's the purchase price minus every cost that's in relation to your client. You want them to know exactly how much money they have because you want to go shop houses with them. So the best way to get an accurate estimate is to do that. And a lot of times when I get requests, I'll be honest, I get a request that says, can I get a net sheet? 5% commission, here's the address. My response, what's the sales price? What is there an HOA? What's the mortgage payoff amount, right? So everything I just said, I'm going to go back. Once you start doing that, it's going to be second nature. And I advise have a template. Make a template in your signature line with all these things. And if it doesn't apply, just put NA, 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 NA. Just you'll never forget if it's already written in a template. It's fill in the blanks, and that's it. And you're going to get your estimate much quicker and more accurate.
All right, another question?
Sure, Jackie will send that
Yeah,
all over.
I have one.
Mhm.
Yeah, no. And these are also good
yeah.
questions that you guys should be asking either before a listing appointment, during a listing appointment,
Mhm.
before you're getting that sign. You know, that way it makes you seem more knowledgeable and that you're more involved with them right off the bat, right? I want to know, do you have a payoff? I want to know, is there HOA? Like you're involved with them right off the bat. So these are really good questions to also ask in your listing appointments or before you actually go on the appointment.
And a
Right.
separate side note, I always like to say, understand your client's situation. Are they in the middle of a divorce? Is there an attorney involved? Is there a court stipulation involved? I specialize in those too. I do a lot of them, where I have to do things pursuant to court orders, and then I do probates too. So everything you can know about your client situation, the better. Sometimes they won't tell you that they haven't paid child support in 20 years. And the math just changed dramatically, right? They owe so many years of child support, and all the math that you thought is null, right? So they're hard questions sometimes, but sometimes they come out without even asking. So just anything else you need to let me know that might be a debt against the property is a nice way to do it in a nice positive way. Anything I need to know about that might pop up. They're going to search the records of the house. Is there anything else that might be recorded that might cause a cost for you to sell this house? That's a really like delicate way of saying it. We're like, well, you know what? Right? And then that comes out. So.
All right.
Uh-huh.
Any other questions before we wrap this up? No? All right. Well, thank you to everyone who joined live, Facebook Live, Instagram Live, and on Zoom. We are 805 Escrow. We are here for all your escrow needs, and we'd love to work with you. Please reach out to me or Michael. We do have a page set up that we're going to send to everybody who attended. This page is going to have some of the talking points that we went through today. So each tile will be one of the talking points. We have the purchase agreement, the seller opening package, seller notary items, buyer package. Our Instagram will be here if you guys want to follow us. We'd greatly appreciate that. And then of course, our partner 805 title page is there too. You can get some information on that, or you can come see me. And our team. So me and Michael's information will be here. All the team members' information will be there. If you need to reach out, if you need to get those net sheets, just let us know.
All right. Cool. Thanks.
All right. Thank you.